All right. So here's what we're going to do today. I want to finish lecturing, and then I want to talk about the Brown versus Board of Education case. And then I want to talk about the rule of law article. And then if we have any time left over, which we should, then I want to talk about two current events that I saw articles on in the paper this week that talk directly about things that we're learning this week. So if we have time at the end, we'll do that. And if there's extra time, we'll do a couple more truths and a lie. I want to remind everybody, just go over again how everything works. You'll have a quiz that's due Monday night at midnight. It's take home. You do it online. It requires the lockdown browser. It will be multiple choice, true, false, matching, no short answer or essay questions. And it will cover anything that I've said in the lecture, anything that's in the outline, the Brown case, and the rule of law article. Yeah, it'll grade. It should grade it right after. If it doesn't, then I just hadn't turned that on. But yeah, you should know. And then the key terms. So pull up that for a second. Your glossary sort of for this week, the things I want you to be able to be fluent in. For every definition, under it, you'll see a blue example. I'm not testing you at all on the example. So you don't need to know that. Don't worry about memorizing that. I just want you to be familiar with the definition. Does that make sense? All right. Don't be nervous about the quiz. You're going to have a bunch of quizzes. They all, if you've read the things and you've listened, everybody will end up making A's and B's. I feel like that if you take the first quiz and you are not happy with how you ended up, I'm glad to talk to you about it. Also, if you see a question that you don't think was right or fair, ask me, because that it's not uncommon that I've written something that makes sense to me but doesn't make sense to y'all. So I'm always open to suggestions on that. All right, let's jump in then and finish the lecture outline for this week. So we talked a lot on Tuesday about the different sources of law. And we talked about constitutional law, both at the federal level and at the state level. We talked about statutory law being laws that are passed by Congress on the federal level and state legislatures on the state level. We talked about administrative law, that is law that is made through rules created by administrative agencies at both the federal and the state level. And we talked about case law, which is the body of law that comes from written decisions by courts. Those are four main areas that I wanted you to be familiar with. I want to talk about some of the distinctions and differences in ways that we categorize the law that I think are important for you to be able to speak about. So we have two really main bodies of law. I'm not talking about sources of law anymore, but these are just, if we're grouping them all together. All right, we've got criminal law and civil law. Criminal law are the laws that we're familiar with those. They'd say what kind of conduct is prohibited, what actions are prohibited. If we violate criminal laws, murder, traffic tickets, assault, things like that, fraud, those are all criminal laws. If we violate criminal laws, then we face punishment either through fines or jail time or things like that. Criminal law is designed to do a few things. It's designed to punish. That's the purpose of it. It is designed to deter folks from acting a certain way. I am going to be a lot less likely to steal from Mr. Lee because I know that I might go to jail for it, right? If there were no penalties, I'd be much more likely to engage in that activity. So deterrence is a purpose of criminal law. Rehabilitation is a purpose of criminal law, maybe not so much as much as the punishment and the deterrence. In criminal law, the person who brings the lawsuit, who arrests you and charges you or me, is a government entity. At the state level, if I violate a state traffic law, that case is going to be State of Georgia versus Tebow. State of Georgia is the plaintiff, the one who's bringing the case, and the defendant is me, the person who the case is being brought against. We'd much rather be a plaintiff than a defendant, generally speaking. All right. In a criminal case, I have the right to a jury, and the jury's decision as to whether or not I'm guilty or innocent depends on whether or not they think that I've committed the crime beyond a reasonable doubt. You're already smiling at me, Scarlett. What are your thoughts on that? Oh, I thought you were not believing me, or just a nice, happy, smiling, pleasant face. I like that. All right, good deal. Beyond a reasonable doubt. We confuse that a lot of times with beyond a shadow of a doubt, beyond any doubt whatsoever. That's not really the standard in a criminal case. Beyond a reasonable doubt means if there's any other reasonable explanation besides the fact that the person committed the crime, then the jury should find them not guilty. Beyond a reasonable doubt. That's criminal law. State of Georgia versus Tebow, if I violate a federal criminal law, then it would be the United States of America versus Tebow. Built for punishment and deterrence mostly. Beyond a reasonable doubt is the standard. Civil law is the body of law that's everything outside of criminal law. It's everything else. Divorce law is civil law. Tax law is civil law. Personal injury law is civil law. Civil is everything that's not criminal. Why do we have civil law? Well, in criminal law, it was because the government needs to have certain rules that we follow, or else we are punished, and that we respect so that we don't break them. But in civil law, we're more interested in settling disputes between individuals. Civil law is concerned with compensating the injured party for whatever it is they've lost or had damaged or been injured. What can get confused? Well, I'm sorry, I'm going to go there yet. In civil law, you can also have juries. Sometimes you'll just have a judge. But in civil law, we don't find somebody guilty or not guilty. We find somebody liable, responsible, or not liable. So I want you to be able to use the correct terminology there. We sometimes will say in a civil case that somebody was found guilty of. That's not the right terminology. Civil law is about compensating victims or injured parties to make them whole for what they've lost or been injured. And liability for that would lie with the defendant if the court finds that they're liable. The standard in a civil case is not beyond a reasonable doubt. It is by a preponderance of the evidence. All right, so beyond a reasonable doubt is pretty high up here. Maybe not 100%, but I'm pretty sure that the person did it. No other reasonable explanation but that they did it. Preponderance of the evidence, if you think of the scales of justice, that's just one being a little higher than the other. 50.1% to 49.9%. And that's a lot lower than our beyond a reasonable doubt, right? The reason for that, one of the reasons for that is that the punishments that are involved with criminal law, jail, loss of liberty, potential loss of life, depending on what the crime is, we want to be dang sure that the person who is suffering those consequences did, earn those consequences. In civil law, we're not as concerned with that. So it's really a little bit more than not in civil law. Preponderance of the evidence. We'll talk about this the whole semester. I understand this terminology is new to you, but I want to get you by the end when we're talking about civil cases. We're talking about liability. We're talking about criminal cases. We're talking about guilt or innocence. One thing that's real confusing to non-lawyers is that there is significant overlap between criminal law and civil law. Sometimes the same actions, the same circumstances can be criminal but also may carry civil liability. A famous example of that is O.J. Simpson. Did anybody in here not know O.J. Simpson? I had a foreign student in my earlier class. I had to explain to her that O.J. Simpson allegedly murdered his ex-wife. Y'all remember this? You've probably seen the Netflix stuff. This dates me. This was back when I think I was in law school when O.J. Simpson case became about. But if you're not familiar with it, he was arrested and charged with murder of his ex-wife and his ex-wife's boyfriend. He was found not guilty by the jury because they did not, that group of citizens did not find that he did it beyond a reasonable doubt. Her family, the ex-wife's family, sued him under civil law for wrongful death. And they sued him not to put him in jail, because you don't do that. That's not a consequence in civil law. They sued him to recover the value of her life and certain amounts that would compensate them for the pain and suffering that they endured as a result of his actions in killing her. So in civil law, when the family sued OJ, that's a separate case. The cases don't go at the same time. It's not the same jury. It's not the same judge, not the same standard of evidence. The jury in the criminal case said we can't find beyond a reasonable doubt that he did it. But in the civil case, they found that he was liable by a preponderance of the evidence. And they owed him to pay, the court ordered him to pay a bunch of money to the family to compensate them for their loss. So that's an example of how one act can result in criminal law activity and also civil law activity. And an example of how somebody could not be guilty under the criminal law, but be found liable under civil law. There's a lot more crossover than that. We'll talk when we get into criminal law and some tort law about things like assault. If I punch Maria in the face, first of all, she's going to destroy me. I'm going to pay for that. But if I do that and she calls law enforcement, they might charge me with the crime of assault. But let's say that she required reconstructive surgery. This is fictional, obviously, because I couldn't do this. But you required reconstructive facial surgery, and it was painful, and you missed work, and you were out wages and all that. Not only could the government bring a case against me for the crime of assault, she could sue me under civil law for assault and ask for medical bills, pain and suffering, lost wages, all that kind of stuff. If law enforcement came up here and decided that they were not going to charge me with the crime, she can still sue me under civil law for assault. They're not dependent on each other. She would need that remedy. She would need to be able to do that because under the criminal law, she's not going to get made whole. The state of Georgia is interested in punishing me for doing that and for showing every other citizen that if you do that, you will be punished in order to deter that kind of conduct. The state of Georgia is not so interested in making me pay for her medical bills or her pain and suffering or her lost wages and all that. It's not that they don't think she deserves it. It's just that they don't necessarily have the resources or the ability to bring that case on her behalf. Civil law gives her that remedy where she can sue me on her own to recover all that. That's the basic difference between civil law and criminal law. Most of what we talk about is going to be civil law. We are going to talk about criminal law in the business context because that does occur. But most everything else we talk about, contracts, employment law, tort law, intellectual property law, all that falls under the big umbrella of civil law. Your outline talks about the difference in substantive law and procedural law. Really, all that means is that substantive laws talk about what we can and can't do. They have substance to them. Procedural laws just govern how a court case ought to go. So if the state of Georgia has a law that says if I'm sued, I have the right to respond in 30 days, that's a procedural type law. If the state of Georgia has a law that says I can't go around hitting people, that's more substantive. We talked some on Tuesday about the difference between federal and state law. Just remember that federal law is law that emanates from statutes passed by Congress, executive orders of the president, cases decided by the federal court system. State law would consist of statutes passed by the state legislatures, orders from the governor, and cases decided by state court systems. We talked we talked a good bit, I think, about constitutional law, so I'm not going to get too deep into that today. But I do want y'all to be familiar with some basic general ideas that we get from the Constitution. One is, I think all our seats are full, so if you don't mind in the back, I apologize. I have asked about getting another desk, but that has not materialized yet. Separation of powers, we already talked about that the government is set up so that we have three separate branches that have checks and balances on each other, that neither branch is more powerful than the other. There is something in the Constitution called the Commerce Clause. And when the Constitution was drafted, 1800s, the idea was that regulation of business would be left to the states to do on their own. Back then, commerce, business was pretty much local. And we're talking horse and buggy. We didn't have internet orders. We didn't have companies that are shipping goods on 18-wheeler trucks down interstate highways of the nation. Most business and commerce was local. So the founders set up, they anticipated that the states would regulate that under the context of society as it was then. But what's happened now and the way we are today is that there's hardly any business that is just purely local. I mean, I could have a produce stand on Winton Road and sell tomatoes from my backyard garden. But there are plenty of motorists that are coming through in Atlanta down I-85 that stop on Winton Road to go to Chick-fil-A on their way through town that might stop and buy a tomato from me. I mean, my customers could be from other states and likely would have plenty from other states. Columbus being situated right across the river where we can see Alabama means that almost every business here has customers on both sides of the state line. The reason that interstate commerce is important is that the Constitution said that any interstate commerce between the states, that would be subject to federal regulation. So when this all got set up, most commerce was local. The states did most of business regulation. Today, the flip side is true. Almost all commerce is interstate, and that means that states don't really regulate business as much as the federal government does. That is all because of the Commerce Clause of the Constitution that says that the federal government can regulate commerce between the states. We talked on Tuesday about freedom of speech. The reason that's important in the business context is that speech is not limited to just words spoken or written by a human. Corporations can speak also. So they also enjoy the protections of the First Amendment right to freedom of speech. There was a case several years ago involving a law that was passed that prohibited companies from, or tried to prohibit companies from giving money to political causes or candidates. And those businesses sued and said that's unconstitutional because it violates our right to freedom of speech. And you might be thinking, well, how does that fit into freedom of speech? The courts decided that corporations can speak in a lot of ways. Of course, they can speak through advertising, they can speak through, some of the written stuff, but they also can speak politically by supporting candidates or causes. That is protected speech. So businesses are not only protected, but they're also regulated. I mean, businesses don't have just a blank check or free reign to say whatever they want. The limits that apply to free speech of individuals also do apply to businesses as well. I just want to highlight that in the context of First Amendment. Due process is enshrined in the Constitution, and that's the general idea that the laws of the country or any state must be fair. An example of an unfair law would be if the state of Georgia said, if I'm arrested for a crime, that the judge can go ahead and sentence me to a number of years in prison without me having a trial. That'd be a violation of my due process rights. It's unfair. If the state of Georgia passed a law that said, at my criminal trial, people can testify about me, but I can't ask them questions about what they said. That's unfair. That would violate my due process. Also appreciate that the due process clause in the Constitution, this idea that all laws have to be fair, it's one sentence. No person shall be deprived of life, liberty, or property without due process of law. The freedom of speech that we enjoy and that's protected was just one sentence as well. These are broad constitutional law provisions, much different than specific statutes or case opinions written by judges that are pages and pages long. Different types of law. I want you to be familiar with the idea of equal protection that the Constitution protects. Again, one sentence. The state may not deny any person within its jurisdiction the equal protection of the laws. That's all it says. But we've got volumes and volumes of case law and what that means. The case that we're going to talk about today, Brown versus Board of Education, directly involves whether or not segregation violates equal protection. Does that deny citizens the equal protection of the laws when it comes to segregated public schools? We're going to get there in a minute. Those are just some broad constitutional ideas that I like you to be familiar with. That brings us to Brown versus Board of Education. Unless anybody has any questions on the lecture outline so far. Any questions? All right, I know I didn't do that good of a job. Nobody has anything? All right. So how about Brown versus Board of Education then? So, when I told you that the plaintiff is the person who brings the lawsuit and the defendant's the person the lawsuit is brought against, who are the plaintiff and the defendant in the Brown case? The plaintiff is who? Brown. Brown is actually shorthand for a number of plaintiffs. They just didn't list all their names, right? We shortened it to Brown. But Brown represents a group of who? Parents who sued because why? Right. Their children, these were African American parents who tried to enroll their children in white schools and were denied. All right. So they sued who? Who's the defendant that they sued? Board of Education. Very good. And so this case started out in a court in Kansas. And what happened at that first court level? Who won, Brown and the parents or the Board of Education? Board of Education won. Then Brown and the parents exercised their right to appeal, take it on up to the next level, talk to your boss, right? The next level, Board of Education won again. They said, let's keep it on going. So they went to the U.S. Supreme Court. And that is the decision that you have read for today. So that was the third court to hear this case. First two times, the defendant won. At the Supreme Court level, who won? The plaintiffs won. The Brown and the parents won. That's right. So if you had to, if I asked you to tell me in one short sentence what the issue is, what's the question that the court had to decide in this case, what would you say? You raising your hand? Good. Gonna call on you anyway.
Does the segregation of public schools solely on the basis of race? I'm just reading off of.
You're right. So keep going.
Even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal education opportunities.
Okay. We can shorten that. That is right. Does separate but equal in the field of or in the context of public education violate what?
The equal protection
Of
the U.S. Constitution.
very good. So that's the issue here. Does separate but equal in the context of public education violate the 14th Amendment guarantee to equal protection under the U.S. Constitution? That is exactly the question that's presented. We've read the case, so we know what the answer to that is, and we'll get to that in a minute. When I told you that courts have to follow precedent or else they have to give good reasons why they're not, this is an example of the court now telling you what the law is, how it's been interpreted in the past, and then why they are not going with those past decisions, why they are overturning the precedent. They start that analysis by saying, all right, first of all, let's look at when this law was passed. So this Kansas state law that said public schools could be separate, when was that passed? 1879. All right, so that's the law in question. This case is being decided when? 1954, right? So this law had been in place from 1879 to 1954. It went back a ways. When was the Equal Protection Amendment, 14th Amendment passed? 1868. All right. So the court said, all right, we're going all the way back to the beginning. Let's see if we can figure out what the drafters of that amendment of the Constitution meant when they wrote the Equal Protection Clause. Let's see if we can figure out, based on their intentions, how public education, separate but equal, would fit into that. All right, so then they go and talk about actually what public education was like when the folks wrote the 14th Amendment. What do they tell you about public education in the 1800s? One of the Garretts. What was public education like in the 1800s? It was segregated, yes. What about as it relates to the government's responsibility? It was mostly private, at least in the South, and it was mostly for white children, right? Did the government in the 1800s concern themselves much with educating children? It just wasn't a job of the government. We can't fathom that because public education is one of the most important functions of government today. But when they wrote the 14th Amendment, public education wasn't a big deal. So the court says that doesn't really help us very much to look at that. They then go and look at some of the past cases. And the main precedent in this case, the case that the lower courts followed when they found for the defendants was what case? Plessy v. Ferguson. Plessy v. Ferguson said what? What does it say, Mr. Clark? What's Plessy stand for?
Plaintiff.
Plaintiff, but what was Plessy about? Anybody? Go ahead. I'm sorry. Go ahead. I didn't give you a chance to finish.
It was not the buzz, but the.
You're right. It involved public transportation. That's right. And it said the courts had found that separate but equal was constitutional in the context of transportation. Had the courts ever had this exact question before about separate but equal in public education? They hadn't. Your case talks about some previous cases involving a law school and a graduate school where they found that separate but equal was not constitutional. But the court had never confronted the question in the context of state public education. Plessy said you could do separate but equal in transportation. This court's saying, are we going to take that precedent and also apply it in the realm of public education? when the court was looking back at old decisions and precedent, they said we really used to, or in the past, we have evaluated separate but equal according to tangible factors. Are the school buildings the same? Do they have the same curriculum? Does the state pay for teachers for both of them? Do they both have busing or access? What are the tangible factors that we can compare? Because in past cases, as long as tangible factors were equal, then we're okay constitutionally. Court says we can't do that here. We got to look at the intangible effects and factors that are at play. What does the court say about the intangible effects of segregation?
It makes them feel inferior.
Good. Excellent, Mr. Clark. That it makes the people who are being separated feel inferior. What else? There's more. Lose opportunities, right? You're not networking with the same people. You're not part of a community of like-minded students who are studying the same thing, that are just as smart as you, who have the same opportunities. One of the main points, I think, is that it says not only does it tell somebody they're inferior, but how much more powerful and damaging is it when it's the government telling them they're inferior, when it has the sanction of law. So the court said, when we look at the intangible factors, there's no way we can conclude that separate but equal gives citizens equal protection under the law. There's just no way that we can say separate but equal is consistent with equal protection. So if we said that this issue before the court was, does separate but equal in the context of public education violate the 14th Amendment to the U.S. Constitution? If I asked you what is the decision of the court in a one-sentence summary for this case, what would you say?
Separate but equal is not constitutional.
Excellent. Be more specific. Separate but equal is not constitutional because it violates 14th Amendment of,
The United States Constitution.
all right, and I'll be even more specific. Separate but equal in the context of public education does violate the 14th Amendment guarantee of equal protection under the U.S. Constitution. That's right. The reason I'm being picky about that is to illustrate to you that when folks take cases to court, it's important for the lawyers, or the job of the lawyers, to look at past cases and argue ones that support their position and differentiate between ones that don't. So if I represented the parents in this case, and I'm going in front of a court, and the judge says to me, Mr. Tebow, we have precedent already. The courts have decided, the Supreme Court has decided Plessy versus Ferguson, and in that case it said separate but equal was constitutional. Why are you bringing this case? I would say, because, Your Honor, that case involved public transportation. This case involves public education, and there are differences in that. That's my angle. If I'm defending the Board of Education, I'm going to tell the court there's not that much difference between public education and transportation. It's still things that the government provides. I would focus on the tangible factors that have been equalized, because that's what past courts have used to uphold that. So I'm being specific to demonstrate to you how the lawyers would use precedent and use that to shape and color their arguments as they try to change the law. So this is an example of a case where the court overruled precedent, overturned precedent, and changed the law. So going forward, the separate but equal doctrine, as it applies in public education, was no longer constitutional. That was pretty much the end of any laws that tried to make anything governmental separate but equal. If the state of Kansas then turned around the day after this case and passed a law saying that the races were going to be taxed differently, and that got challenged in court, the plaintiffs are going to say, Judge, the Supreme Court has found that separate but equal does not apply in public education. How in the world could we say that it's okay to make separate but equal in taxation? And I've just said that they're going to be taxed differently, so that's not really separate but equal. If I'm on the other side, I'm going to say, if I'm defending it, I'm going to say, well, that was in public education. We're talking about a whole different matter, and we've got to look at the effect of separate but equal and tangible and intangible factors through the lens of taxation, not public education. That was an argument that no one was willing to make. The Supreme Court's pretty clear in their rationale that there's not really any area of governmental responsibility where we were going to be able to segregate things. An illustration of kind of how case law works and how lawyers argue those things. Anybody have any questions on Brown versus Board of Education? No questions. All right, if that's the case, then let's move to your article on the rule of law. In my first class, I only had one student that said that they were familiar with the idea of the rule of law. How about in this class? Who read this article and was like, oh yeah, I know what, or saw the title and was like, I know what the rule of law is? Got one? I see some nodding. Who has not heard this terminology before? All right, most everybody else. You might not have heard the terminology, but you know the rule of law. It's part of your everyday lives, whether you realize it or not. Cody, if you go to the ATM machine after class, you put your card in there and you put your PIN in and you ask to withdraw $100, your account has $1 million in it. You just want 100, and they don't give it to you. What are you going to do? What remedies do you have?
I should have access to my money, but I don't know.
Because why? Because it's the law. You put your money in the bank, they guarantee that it's yours when you need it. That's the law. If they told you, Cody, sorry, buddy, we don't know what happened to your money, but it's gone. You know that you can sue them. And you can prove that you deposited $1 million in that bank, and then you can show that the law says that guarantees that you get it. And the fact that they lost it is their problem. You know you have a remedy. That's the rule of law. Who drove here this morning and stopped at a red light? Everybody? Columbus has more red lights, I believe, than any other town in the country, but beside the point. You stopped because why? It was the law. What if there's nobody coming? You still stop? Yeah, we do. The rule of law creates order in society that gives us the reassurance that we can take certain actions, that we can act, govern ourselves and knowing that our rights will be protected. I didn't say that very well. The rule of law gives us reassurance that our rights will be protected by the courts, by the government. How does the rule of law apply in business? Well, if I was going to, if I'm going to invest, let's say I'm building a building here at Columbus State, I need bricks, okay? And I go and I place an order with Mr. Kelly's brick company for $2 million worth of bricks, and his company is in Michigan. Am I going to do that if I'm worried that I might not be able to A, get my bricks, or B, get my money back from him? No, I would never do that. None of us would. But Cody went and put his $1 million in the bank. He gave it to them. Only because you know you can get it back. I'm going to buy those bricks only because I know that I'm either A, going to get my bricks, or B, going to get my money back. You all know the rule of law because it's how we act every day. if I wanted to invest in, think about a country, maybe an underdeveloped country that has a weak rule of law, am I going to buy $2 million worth of stuff from them? I'm not as likely to, Mr. Barker. Why? Yeah, I'm worried about whether or not my rights will be protected, right? So this rule of law idea guarantees protection of us from the courts. It gives us predictability in business. It allows us to conduct ourselves in a way that we have certain expectations about what will happen if we do or don't. Your article also says that the rule of law is more than just protecting and ensuring our rights. Also, it talks about how the laws apply to everyone equally. Did anybody read that and be like, well, I just don't know about that? Anybody have any thoughts on that? Yes, sir. Tell me about it.
Oh, no, I was just saying, I wouldn't agree.
You wouldn't agree with that? Then tell me why.
Why wouldn't I agree?
Mm-hmm.
It's basically like, from what I see what's going on now, I just wouldn't agree with that.
I agree with that. Who else? Show of hands. Who else agrees with that? That's not. I guess a better question is, do we believe absolutely 100% that the laws apply to everyone equally all the time? The rule of law says they should, right? But do they? We all have some questions about that. Our own experiences will question that. There are probably some, not probably, I'm sure that there are some non-citizens who are in our country legally who are worried that the laws are not going to apply equally to them. There's a great distrust of law enforcement in certain communities about the law not being enforced fairly or equally across racial lines or across socioeconomic lines. There is a distrust, I would say, amongst general population about maybe that the law doesn't apply as equally to people who have money and influence and power and means and access to influence the system. I think that'd be a fair criticism too. Not just business owners are having their rights protected, but workers are too. Anybody here work in a warehouse? Work in a warehouse? I'll ask Maria. If you're working and you get injured on the job by something that's not your fault, you know that you're going to be compensated or remedy. You have a remedy for that. You know that your employer, USA, is going to be responsible for that. Now, we could argue about whether or not you're going to get everything that you're due. But generally speaking, you go to work knowing that you're protected by safety rights, okay? That they can't send you into an unsafe warehouse or an unsafe area, that they can't give you a car that's unsafe to drive, that they can't give you a weapon that is unsafe, that is defective, okay? We all know that we come to work, we have certain rights that are going to be protected. So it's not just business owners, but as workers as well. Rule of law also means that there are checks on power. This is another area where I would expect some pushback. I know this is an area where I would push back. In a pure sense, the rule of law would say that the branches of government have checks and balances and that no one is more powerful than the other. We don't necessarily see that playing out that way now. The rule of law also would say that courts, the job of the courts is to decide cases and disputes fairly, impartially, without regard to personal biases, political beliefs, political affiliations. In its purest form, that's how the rule of law would do it. In its practical, actual form, we don't really think anymore that judges are as impartial as they ought to be. Or at least I don't. What about y'all? We see more and more. Somebody brought up a great point in the first class. When you read an article now about a decision that a federal judge has made, they almost always say which president appointed them. Who cares? It should not matter. But they'll say, well, so-and-so ruled against the Trump administration, and this judge was appointed by Biden. That shouldn't matter. You'll see an article that says this judge ruled against the Trump administration, and he or she was appointed by Trump. Again, it's curious to me that we find that we've now got to identify which president appointed federal judges whose job is to administer justice without regard to partiality or favor. We pay a lot of attention now on the Supreme Court to which justices are liberal and which ones are conservative and which ones were appointed by which president. Again, in its purest form, the rule of law would not care about any of that. The checks and balances are also being tested, and we talked about this a little on Tuesday, by the president trying to push the boundaries of his executive authority to see what the courts will limit on that. Any thoughts on our discussion of the rule of law? I would say that an important part of the article is that it talks about how, at its heart, the rule of law is really about trust. Cody gave the bank $1 million because he trusted that they would follow the law. And he trusted that if they didn't follow the law, a court would enforce his right and have his back. He trusted that law would protect his money. He would not lose his money under the law. We operate like that all the time. All of our actions, both personal and business. There are 2 articles from this week's current events that you know what? I don't know that I posted them for y'all. So I'm going to tell you about them. I'm not testing you on these, so don't worry about that. I'm bringing them up because I want to illustrate the real world implications of stuff we're talking about. And I will post them in case anybody wants to go and read them later. Fine. But again, not on your quiz. The first involves the rule of law and the fact that under the rule of law, if a court tells us to do something, we do it, right? Because this judge ordered it. I have clients all the time that they ask me, what do I do about this? I'm like, you do exactly what the judge told you to do. You do exactly what that court order tells you to do, because if you don't, the court's going to punish you for it. I had clients back when I did family law are like, I've been ordered to pay $3,000 a month in child support. I can't do that. Well, you better figure it out because that's what the court ordered you to do. The first article comes from the Atlanta Journal-Constitution. It's from yesterday, maybe even this morning. And it talked about the Fulton County Commission, which is a local government entity. Fulton County, if you don't know, is the Atlanta area, metro Atlanta area. Not all of Atlanta, but the central part of Atlanta. And there is a state law in Georgia that says, here's how we're going to compose the commission. Democrats can nominate 2 people, Republicans can nominate 2 people, and the commission will approve and vote them in. Well, the Republicans nominated their 2 people, and the Democrats refused to vote them in. So the Republicans sued and said, this is a violation of the law. We've made our nominations. The law says they've got to approve them. The judge heard the case and said, you're right. That is what the law says. Democratic members of the Fulton County Commission, I order you to approve their nominees because that's what the law says. The Democratic folks on the commission said, we don't care. We're not voting for them. We get, Judge, that you're ordering us to do it, but guess what? Well, we're not going to do it. This dispute is not over. There could be appeals, and if the judge could try to punish the folks who are defying his order. But I raise this to you today as an example of the rule of law being really tested and pushed. We have seen, at least more than any other time in my lifetime, elected public officials saying, I don't care that that's what the law is. I'm going to do this anyway. I don't know that I've ever seen in my lifetime this kind of pushback on court orders. Some of it might have to do with testing the limits. Some of it might have to do with the belief that the system isn't working right. Some of it might have to do with a loss of confidence of people in the system. I think this is judges just a mouthpiece for Republicans or a mouthpiece for Democrats. And I don't really think this judge is behaving impartially. And so therefore, in response to that, I'm not going to follow what he or she told me to do. We're seeing this tested really in ways that we haven't seen tested before. The second article that I am going to put up for you in case you're interested involves administrative law, which remember is laws that consist of rules passed by administrative agencies. So the United States Department of Education is an administrative agency, and it is tasked with making the rules that the country's schools got to follow. And one of the rules that it had made in the past, I can't remember how long ago, was that all public schools must have a certain number of teachers. They must devote a certain amount of money. They must implement a certain curriculum to help children that don't speak English learn English. That was the law because it was a rule made by the Department of Education. Recently, the Department of Education said, you know what? We're going to take that rule back. We're striking that rule down. Schools are no longer required by federal law to provide this extra education and help to students, young students who can't speak English.
So basically like ESL classes.
Yes, ESL classes. And that doesn't mean that schools can't do that. It just means it's not the law anymore. And that if Blanchard Elementary decides that we were paying 2 teachers to do this special class for ESL students, we don't have to do that anymore if we don't want to. Before, if they didn't do it, the federal government could come in and sue them and say, you're not following the law, you've got to do that. So that's an example of the law changing dynamically right before our eyes. Happens all the time. This is not, I'm not raising the alarm on this to y'all. That like, oh my gosh, the Department of Education has changed their rules. Administrative agencies are always changing rules. I just want when you see these things now in the news to be like, oh yeah, I know the context of how this fits into our frame of government. I know the context of how this fits into the idea of the rule of law. And you can better evaluate the information that you see and read and hear, all that kind of thing. So we're not quite done, but I want to wrap up the substantive portion of this by saying your quiz will be due Monday night, midnight. It's multiple choice, true, false, matching type stuff. It covers your key terms, your lecture outline, even stuff that I might not have talked about. It covers anything I have talked about. It covers the Brown case, and it covers this rule of law article. It is designed to see if you read it and that you came to class and paid attention. It is not designed to be tricky or to try to see if you're some master of law. I just feel like if you read and you come to class like y'all are and listen, you have learned what I wanted you to learn. The only way for me to do that is to test you to make sure you'll do it. In the time we have left, which is, we've got a few minutes left. I want to do a couple more 2 truths and a lie. So I'm going to start with the Garretts. We'll start with Jones. Yep. Tell us your 2 truths and a lie. We're going to vote on it.
So majority will expand.
All right. Likes of dogs.
Do what?
Go ahead. You like the dogs,
I'm in the top 100 golfers for my age range in Georgia,
which is what age?
18 to 21.
Okay.
I have 2 half